Okay. So last week we devoted the 2 hours to analyze the Universal Declaration of Human Rights, the content. But this week we are going to deal with the same U.D.H.R, but as regards language. We are going to analyze vocabulary, some false friends, some collocations. I'm going to explain what collocations are. So let's share some PPT. Let's say, are you seeing this PPT?
Yeah.
Okay. Diplomatura en Inglés Jurídico. Okay. So then I'm going to send you the PPT, and it is going to be uploaded to the platform also. Okay. So today we are going to deal with contents of this part of the unit, the guide to the classroom activities, 10 minutes, what effective remedies are. I think that last week or the other week, we dealt with effective remedies. We are going to study again what effective remedies, the term, this is a term, a collocation, what effective remedies are. And the International Court of Justice, which is a marvelous, great activity related to the International Court of Justice. Let's think big. And collocations related to criminal justice. Collocations from this book, which is the photocopy book, and it is Cambridge Collocations in Use Advanced. There I have one chapter related to collocations on criminal justice. Okay. First of all, contents of this unit. This is a slide that you are going to find in this part of the unit. Effective remedies, International Court of Justice exercise, and the UD.H.R typical vocabulary exercise. You are going to find this in the classroom. Yes. So the first thing that I'm going to do is to explain what you are going to find in our classroom. I'm sorry for Silvana. I think that Silvana has no way to enter, but then Silvana, I hope you will have.
Yes, thank you.
I don't know why, because now, because you know that 10 days ago, we had the problem that Mariano, who is the one that has to enter the people inside the classroom, his brother had died because of the COVID. Then they said, well, okay, now Mariano is on again, so, but I don't know why you are not here again. So
sorry, no, it's okay.
It's
okay.
a pity.
No problem.
Everyone is going into the COVID. It's terrible. In fact, what we are doing here is surviving by studying, by being positive.
Yes,
Doing something. Yes, thinking is not good. Studying is the best thing, or teaching, or doing something, as you said. Okay. So we are going to analyze the classroom. Now I'm going to share some bits of the classroom, so for you to analyze the classroom. Yes. So let's see. Sorry. Here. No, not this. It's not so easy. You have to switch rapidly. Here. Campus. Are you seeing the campus or not? Can you see the campus?
Yes, I can see that.
Now we can. Yes.
Okay.
Yes.
So you know, here up to this part, up to 1421, where it says May 1421 May, 21st May, watch the videos. Up to this part was last week. Now we are going to deal with only 3 activities, 3 parts, because it's the linguistic part of the Universal Declaration of Human Rights. Is Unit 1, second week, effective remedies. So you are going to encounter this, as you said, as you saw. So yes, it's the exclusively legal English exercise. It's just a banner. Then you are going to find this activity related to effective remedies. So you open it, you download it,
Okay.
and so it opens like this. This is a paper prepared by me or by the team related to effective remedies, and it's a theory, and we are going to talk about that. We are going to deal with it. So we are going to study this paper. So easy your activity later on, because we are going to chew this paper. Then you say, well, I saw this during the online class lesson. Okay, so this is effective remedies. Then you have to see this, because you know that I am also a student at another classroom. I study Hebrew, Hebrew at the Universidad de La Punta. I study Hebrew with the same platform. So sometimes you devote your time to this part and you forget this other part. It says, 8 archivos, 2 sitios, un tema de debate. All of this is also mandatory because it's important. So, 8 archivos in Spanish. Here you have Charter of Fundamental Rights of the European Union. Some collocations. There are the effective remedies again. Reading, matching activity. Another document related to remedies. I think that the schedule here maybe is not updated. Some topics and the U.D.H.R. that some of you asked for during the week, the U.D.H.R. So all of this is 8 archivos at the bottom here. Okay, 8 archivos. 2 sitios. Probably they are the 2 movies or the 2 short videos that we have to watch to solve the activities. And then un tema de debate probably is a forum, yes, to post your result for effective remedies. It's a watching activity with a matching activity with arrows. And so you have to post your results here by saying responder. Okay, then I go back. You know that is half of the activities. Then the last part is activity related to a Universal Declaration of Human Rights, and it's called 70 Years Perspective Assignment. And it is related to a video that we have to watch. Probably we're going to deal with this today, if we have time. 70 Years Perspective. You know, this is a link to the video. I checked it and it works. And then in fact, it's fill in the gaps activity. You have to watch the video and fill in the gap. 1, tal cosa, 2, tal cosa, 3, tal cosa. Fill in the gaps activity while watching the video. And that's it for now, for this week. You know that this week is quite easy, as I said before. So, any doubts so far? ¿Alguna pregunta?
No, not at all. It's all quite simple. Thank you.
Yes, this week is quite simple. I think that last week was more difficult. Well, thank you. Thank you because you reassure me. Okay, so I close the campus. Then we move on to... Ahí tengo los alumnos por acá. El cartelito de este por acá. So difficult to share. So we move on to the next activity or next chapter. The next chapter is related to effective remedies. Effective remedies. Some theory. And this is the theory that you're going to encounter in this paper that I showed you, that is inside the platform. Yes. So the index of this paper is as follows. Introduction. Remedy as a false friend. The concept, first of all, the concept of false friends. Then the concept of remedies, the usage, collocations with remedies, types of remedies. And the types of remedies are money damages, non-monetary relief, and I think that there's a third type of remedy. Then analysis of the wording of paragraph 8 from the Universal Declaration of Human Rights. All of this is related to the Universal Declaration of Human Rights, paragraph, in this case, paragraph 8. You know that paragraph or article 8. Well, article 8. So this is the central discussion. Article 8 of the Universal Declaration of Human Rights. Who wants to read, please? Okay.
Everyone has the right to an effective remedy by the competent national tribunals for acts violating the fundamental rights granted him by the Constitution or by law.
Okay.
Yeah.
So in legal English, the first idea of phonetics, I had also that mistake, you know, and that error. It's not that way that you pronounced, is tribunals. Tribunals.
Ah, sí.
All of you, please, all of you, open your microphones and say tribunals. Tribunals.
Tribunals.
Tribunals. Tribunals. You know that I had the same mistake. You know that I used to study all by myself, so I committed a lot of accentuation mistakes because we don't know. And besides, I didn't used to check on the computer. That was another, and it was years ago. So the thing is that I committed a lot of mistakes related to accentuation. So it's important to check the accentuation. So it's tribunals. Okay, tribunals. Remember, tribunals. So this is Article 8 of the Universal Declaration of Human Rights. And remember that Universal Declaration of Human Rights is sort of constitution of all the countries, that it was settled in more or less 1948, if I don't remember wrongly. And so it was settled after the Second World War, and it's sort of constitution of all the world. And it created the United Nations. So that's the Universal Declaration of Human Rights. And so Article 8 says that everyone has the right. It's not a benefit, or it's not something that is an obligation by someone else. No, it's a right. So if it is a right, it means that it's a right against all the people. It's erga omnes, as we lawyers say. All the people. So it's a right to an effective remedy by the competent national tribunals for acts violating the fundamental rights. So any acts violating the human rights, you are granted with a right to an effective remedy to go to the tribunals. Yes, so that's Article 8. So the idea is to analyze what an effective remedy is here. Remember that we're analyzing the wording of the conventions. So, in fact, effective remedies is a false friend. What is a false friend? Any of the teachers here may explain. I will go back. So, any of the teachers here may explain what a false friend is, please.
I think there are words that sound or look like other words in other languages, but they do have completely different meanings.
Okay, any example of a false friend? Plain example.
You did mention magistrate the other class. I remember that in
Which
particular.
Which one?
Magistrate,
magistrate. But this is more or less a false friend coming from legal English. Any other false friend, more simple?
Actually,
Which one?
actually,
Actually, excellent. Tell me why actually is a false friend.
because it means realmente,
Realidad, claro.
y nosotros la pensamos como, claro,
Actualmente.
la pensamos como actualmente.
Excellent, excellent. Any other case of false friends? You know that this thing of the false friends and the collocations, it's typically, it's not just studying English, it's meta language, it's linguistics. So it's better English to study. I love it, really. It's not just grammar, it's going in depth on the language. So I love it. So any other false friend?
There is this word carpet.
Which one?
Carpet, meaning actually like carpet.
Carpet.
Or carpet.
Yes. Tell me what? Tell me the difference.
Like people confuse it.
Con carpeta.
Oh yeah, it's like something on which you step in English, and then people think that it's a carpeta, like a folder.
Excellent. And it is plain. You know that the two categories are plain language or legal language. That is plain language, lay language, language that is not legal. Excellent. You know that well. Here we go on, and so remedies as false friend, and we have been talking about this, but it says remedy as a false friend, or a false cognate. That's another term, false cognate, because in fact there are cognates that are correct. Cognates are words that are transparent. For instance, I don't know which one. There are transparent words, for instance. Then it will come to my mind. There are palabras transparentes que vienen al inglés jurídico. There are lots of them because legal English, in fact, was developed through French and Latin, and that's why there are lots of transparent words that come from French. To, for instance, in fact, damage in fact is daño. Damage, daño. It could be a cognate because it seems to be daño, and it comes from French. But other words that are false cognates because it seems to be something, but it's in fact another thing. So a false friend or a false cognate, as you know, is a word or expression that has a similar form to one in a person's native language, but a different meaning. And it comes the example of actually, which means something like in fact or realmente, as you said, and se puede confundir con la palabra actualmente, which means currently, actualmente, currently in English. So in legal English, there are lots of false friends, probably because of the origin of legal English, which is influenced by French and Latin. So if we say a remedy, remember the terms, effective remedies. If we say remedy, it is a false friend because it seems to be un remedio. Por eso puse el cosito del remedio acá. But in legal English, it means something completely different. So the concepts of legal remedies are consequences of acts of omissions against the law. Laura, would you read, please?
Yes. Remedies are consequences of acts or omissions against the law. Remedies are also available in case of breach of contract. In fact, the term remedy is a typical contract law expression. Apart from contract law remedies, there are remedies that a judge may grant in favor of a plaintiff in a tort case. A plaintiff is the claimant, the person who files a lawsuit. A tort case is a case in which somebody has been hurt and seeks compensation under the law.
Okay, lots of terms here. Which terms are curious for you, or special for you, or new for you here?
Tort case.
Tort case.
Tort
I've
case.
never seen it before.
Tort case. Yes, you know that tort case is part of the curriculum of seminario, because tort case is a case of daños y perjuicios extracontractuales. That's a tort case. And it doesn't come from torta, no. It comes from tortious, algo de tortura. That the idea is to connect that with tortious or something that causes damages. It's harmful, tortious case. That's why it's tort case, it's not torta. So tort case, so daños y perjuicios. And another word that is curious or new for you? Luis, you may participate.
Contract?
Breach of contract, that's another term, and it comes from contract law, and it comes from the final part of contract law that is related to rescission, resolution. So when a breach of contract is in fact when you don't fulfill your obligations under the contract. So you are in a situation of a breach of contract. Vos incumplís el contrato. That's breach of contract. And there's a third word I think that is new for you. I think. What is plaintiff, you know?
Una parte, ¿no?
Like demandante?
Yes. Demandante, yes. That is plaintiff and claimant. Sorry, I have to see the window. Just a moment. No. Okay. So plaintiff is el demandante o el actor, or yes, that's the plaintiff. And you know that in fact plaintiff is an old word. Today I think that they are trying to replace plaintiff for claimant. Claimant is more modern word. So all of this is full of terms related to contract law, to daños y perjuicios, so damages, tort law. And remedies is also related to tort law. But in fact, it is also in the Universal Declaration of Human Rights. And it's the idea of you as a person who has human rights, and you have the right to go and claim against an state or against a person who is breaching your rights. But the remedies should be effective. For instance, it's not an effective remedy if they ask you to go to, for instance, I am in San Luis and they ask me to go in person to The Hague to claim against someone. I cannot go because I don't have the money, there's COVID, etc. So you are settling a remedy, but it's not effective. So the remedies should be possible to fulfill. That's effective remedy. And so this is inserted in the Article 8 of the Universal Declaration of Human Rights. Okay.
Adela,
yes.
Question from the previous slide.
Yes, here.
Is that a collocation files a lawsuit?
Yes, that's another collocation.
To file
a lawsuit. Yes, to file
Good,
a lawsuit.
great.
Yes. File a lawsuit. Yes.
Yeah.
Meter una demanda.
Yeah.
We lawyers say meter, but no, meter
Yeah,
is not so formal. Okay. Another one. Luis, are you there? You are in silence. Why? Are you there?
Okay.
Acá está. Okay, Luis, you may talk also. Remember, with no shame, please. Okay, usage and collocations. Remember the idea of collocations. Now we are going to talk about what collocations are. You know that one thing that I love are false friends. Another thing is collocation. And the third thing I love are idioms. I love idioms and I love studying idioms. Sometimes I study idioms, then I don't remember the idioms. But the thing is that when you manage to talk with idioms, you really sound more native-like. Okay, collocations is a way in which some words are often used together. As the partner here, I'm trying to see Marcela. As Marcela said, file a lawsuit was a collocation. Collocations are words that have to be together. You cannot use this type of word with another word. For instance, you cannot say, Marcela said, file a lawsuit. Yes, that's a collocation. I cannot say, put a lawsuit. I cannot say, what else? Take a lawsuit. But I can say, bring a lawsuit. Bring collocates with lawsuits also. You know, file, bring, collocates with also. There are certain verbs that go with certain articles and certain adjectives and certain nouns. Generally speaking, words with nouns. Collocation is a way in which some words are often used together and sound natural together. This also refers to restriction. Sometimes you can, as I said, you cannot use some words with some other words. Restrictions on how words may be used together, such as which verbs and nouns can be used together, and which prepositions collocate also. Prepositions are a nightmare, as you know. I hate prepositions. Which prepositions and verbs can be used together with a collocation. There are certain verbs which collocate with particular nouns, adverbs with particular adjectives, and adjectives with particular nouns. Those are collocations. Which are the collocations with remedies? You know, and then you have here a chart, linguistic devices, the false friend, and collocations. Okay, which terms collocate with remedies? So all of this is in the paper that you have to study. So we are studying it now together. Verb collocations. For instance, remedies collocates with seek. Seek remedies. Seek means buscar, intentar, buscar. You know, Luis, seek remedies. Y también puede ser seek remedies, pedirle al juez. To file a lawsuit in order to seek remedies. So I file a lawsuit upon the court, en la corte, to seek remedies. So seek with the remedies. Those two words collocate. Remedies is a noun, and seek is a verb. The non-breaching party will often seek remedies available under the law. Another collocation, allow for remedy, allows for remedies. The legislation allows for various remedies. Or for instance, the precedent is not the legislation, it's a precedent from a judge. A precedent from a judge allows for various, it's not only the Poder Legislativo, but the Poder Judicial. The legislation also allows for various remedies. Yes, please, tell me. Any question? Okay, so sale of goods legislation also allows for various remedies. The franchise agreement allows for various remedies. Then another one, another collocation with a remedy. To grant the remedy. Some people asked what to grant was. No, grounds was the term. That somebody had the doubt on grounds inside the WhatsApp group. Somebody asked what are grounds? Grounds are fundamentos. Yes, the things, that the arguments that we say to fund a decision, una decisión, una sentencia. Those are the grounds. Or the grounds for my right. Yes, the fundamentos de mi derecho, grounds for my right. So, collocation, to grant the remedy, in short, it says, all of these are parts of some text that I take. In short, the court takes a holistic view of the circumstances before deciding whether or not to grant the remedy. So the court grants the remedy.
Perdón, Adela, ¿es como decidir, como resolver ahí?
Grant the remedy, to grant es conceder. To grant
conceder.
es conceder.
Conceder, ok.
Y tiene una idea de poder. I grant you the right. I grant you the remedy. Te hago lugar. Sería hacer lugar. Hacer lugar a lo reclamado. To grant the remedy. Okay. Entonces, now we are going to see collocations with adjectives and modifiers. For instance, remedy for breach of contract. So remedy, and the modifier is for breach of contract. The basic remedy for breach of contract. Another one, an adequate remedy. So as an adjective for remedy, adequate remedy. Sometimes monetary damages will not be an adequate remedy. And it follows on equitable remedies. A major contribution of equity during its formative period prior to the judicature acts was the development of a variety of equitable remedies, such as injunction, specific performance, rectification, rescission, and account. So here is the equitable remedies. Another one is a common law remedy. The only common law remedy, and it could be, for instance, the civil remedy. You have the common law system and the civil system. A common law remedy or a civil remedy, it could be. So that's an adjective that collocates with remedy. Types of remedies. You may have money damages, specific performance, an injunction, and other non-monetary reliefs. And all of this is related to legal English for tort law, for daños y perjuicios. Money damages. Who wants to read, please? And I take some water.
Okay. Money damages. Most remedies involve money damages. Sorry. Or
pecuniary compensation.
Pecuniary compensation to an injured party. Examples: general damages, special or consequential damages, liquidated damages, punitive damages, and others.
Excellent. So this is money damages, which is a type of remedy. Then I have another type of remedy. All of this, remember, is remedy, which is inserted in the Article 8 of the Universal Declaration of Human Rights. Hello, Griselda, are you there? Are you there, Griselda? I don't know where she is. Griselda? Okay, I don't know. Well, non-monetary relief or remedies. One of these, non-monetary relief, is the specific performance. Anai, would you like to read? Or I don't know if you have the mic. Okay.
Yes.
Okay.
Non-monetary relief or remedies. B1, specific performance, where monetary damages would not, sorry, I can see.
Would not be.
Where monetary damages would not be an adequate remedy, such as in a case where the parties contract for a portrait by a famous painter, the court may order specific performance, which involves an order by the court, compelling the breaching party to perform the contract.
Okay, stop for a bit. It's, okay. You know that en Argentina, en español, acá la gente dice la performance. Todo el tiempo, performance, la performance, la performance. But in English, in fact, it is performance. And it is the correct way to say it. I don't know why the people say in Argentina, la performance. Because if you want to say something in English, you should say performance, as it says, and it is, as it is. So it's performance, specific performance. So put the microphone. What?
Oh, sorry. I think it's because it fits the accentuation patterns of Spanish better.
Yes.
The accentuation pattern.
Yes, because it's somehow it's funny. But you know, Anaí, your mistake is the mistake of everyone here. But you should put the microphone on, and all of us are going to say performance, performance, performance. Please say performance. Performance. Because the word is to perform, so performance. How was it about tribunals? Tribunals. With the second one. Tribunals. Okay. So specific performance. Any lawyer who may explain what specific performance is in Spanish?
Se me ocurre intuito personal.
Claro, que sería que el cumplimiento, ¿qué? ¿Cómo el cumplimiento?
De una persona en específico. O sea, vos querés el cuadro que lo pinte, no sé, Picasso, y no lo pinta Picasso. Entonces hay un incumplimiento.
Bueno, pero en este caso es que vos querés que en realidad no es cuando es específico, no es la specific performance puede ser hecho cuando no es intuito personal, cuando es algo que se puede hacer por otro. No, entonces vos reclamás que lo haga otro. Entonces tenés que tener la pieza pintada, y no lo hizo fue Juan Pérez, entonces vos le reclamás al juez, el juez dice, bueno, que lo haga la empresa tal y pase la factura a Juan Pérez. That would be specific performance. Uno viene parties. A ver. Comparing the breaching party to perform the contract. No, tenés razón. Según lo que dice ahí, no sería así. Porque dice que al pintor le está diciendo que haga la pintura. But the thing, specific performance is also when you have the things done by a third person and you ask the defendant to pay for it. Well, but the thing is that you have the painting, you don't have the money. That's specific performance. You know that in the ILEC book, there was a long listening activity related to specific performance, and it was related to specific performance, but in Norway. So it was funny because apparently in Norway they are more interested on the specific performance type of reliefs or remedies than on money, because they think that you should perform your obligations under the contract. Well, okay, thank you. I think that I said it wrongly as regards what it says in the text. Okay.
Sería como compeler a cumplir el contrato.
Contrato, o sea, pero no que te den plata, sino que te lo hagan, lo tengan hecho.
Claro, claro, es como que.
Pero también podría ser, a mí me parece que también podría no ser un famous painter. Que podría ser, si te lo tienen que pintar a tu pieza, que te lo pinten y vos le pasás la factura. Lo importante es que tengas specific performance y no tengas plata. Because it's non-monetary relief or non-monetary remedies, as it says. Okay, some other cases, other non-monetary remedies, the right to rescind or cancel the contract in case of certain kinds of default. In case of breach of contract, that's breach of contract, so you may resolve or rescind the case, resign the case, resign the contract, because the other party was a breaching party. So that's one non-monetary remedy. Another non-monetary remedy, in cases of sale of goods, the right to sale of goods. What are sale of goods cases? Do you know what they are? Any ideas?
Sorry?
What are sale of goods cases? Of goods, Sale of goods cases. It's a typo there, a mistake. Sale of goods cases. What are those cases? What is specific about sale of goods? No, ideas no. Okay, so this consumer law is the law related to consuming things. That's sale of goods. Sale of goods es compraventa. Lo que nosotros decimos, contrato compraventa. That's sale of goods. But the sale of goods part of the law is related to consumer law, the rights of the consumer, you know? And
¿Sería como algo que nosotros consumimos?
Yes, the thing is that, first of all, sale of goods is compra-venta, contrato compra-venta. But in Argentina, at least, derecho del consumidor is a particular part of sale of goods or a particular part of contract law because it's full of rights that are granted on the consumer. The consumer is particularly protected in Argentina, at least. I'm saying that because of Luis. I don't know in Peru. In Argentina, the consumer is particularly protected because, for instance, you may go to court without paying any fees. It's for free. Going to court against the ones that sold the goods or the ones that made the goods. That's a consumer law in Argentina. How is it in Peru, Luis? You may explain us in Spanish if you want. Derecho al consumidor.
Sí, efectivamente. También tenemos aquí unas normas que protegen al consumidor, ¿no? The right for consumer.
Excellent.
Yes.
And how is would you have to pay a fee to go to a tribunal if you are on behalf of the consumer? Or is it for free? En español.
It's free, es
Okay,
libre, ¿no?
that's the same as in Argentina. Excellent, Luis.
Yes.
So, other non-monetary remedies, remember that the term remedy, are the right to rescind the contract, the right to reject the goods. Remember that in Argentina, under our act, Consumer Law Act, we have, I think, 6 days, 9 days, please make me remind it, or 10 days to reject the good, to make the good go back to the seller.
10 days.
10 days, excellent. Particularly if you bought it
Peru
on the
is
internet.
7 days. In Peru is 7 days.
I think that here is 10 days.
Yes.
10 days. Whether you have bought it online or by phone or any distant way, that is the way you may reject the goods. Even though it is not with any fault, it's not a faulty good, but you decided against your decision and you say, I send the thing back. And you don't have to justify that. So that's another remedy, to sell the thing back. And you don't have to pay any money. Yes? Or they have to give you a refund. You know, the term is to give you a refund. Te tienen que devolver la plata. To give you a refund. So another remedy is an injunction. An injunction is an order of the court ordering or directing a party to the proceedings to do or to refrain from doing something, a specific act. That's an injunction. ¿Qué sería acá un injunction? Sería un mandamiento. Mandamiento de que ordena algo, que haga algo, o deje de hacer algo. That's an injunction. And this is a type of remedy. So, So we have to analyze finally, because it's so dense, this part, analyze the wording of the Article 8, the Universal Declaration of Human Rights, when it says, everyone has the right to an effective remedy. So everyone is all the people, persons and private and public institutions, everyone has the right, and it implies that the subject, this person, may enforce, that's another legal term, to enforce, ejecutar, hacer obligatorio, to enforce this right and file a complaint, exercising the right. So everyone has the right to a remedy, the remedy, and which is not idealistic because it's effective, it's an effective remedy. And the right to an effective remedy is an obligation of the state to provide you with a judicial relief. That's another term, judicial relief, como si fuera un remedio efectivo, a judicial relief, when a violation of the right is acknowledged. And this right entails, what is entail? Anyone? This right entails a double dimension. ¿Qué sería entails?
Implica, like that.
Claro, implica, engloba, comprende. Este tipo de términos son muy buenos, hay que aprenderlos para usarlos. Habría que hacer una lista. Cuando uno habla en público, prepara presentaciones o también escribe, pues uno escribe, y entonces poder expresarse y poder hacer la referencia a qué es lo que dice fulano de tal. Fulano de tal dice tal cosa, o tal norma dice tal cosa. En realidad es report speech, porque vos me estás trayendo lo que dicen los demás. So entails, another term is comprises, this right comprises, podría decir comprises, se escribe comprises. This right entails, this right comprises, this right means, podría ser a double dimension.
This article entails.
Yes, comprises sería comprises. This right comprises, que sería comprende. This right means, implica. Entails, comprende, también, comprise. Well, this right entails a double dimension. On the one hand, the procedural right. Ese es también un término muy legal, the procedural right to an effective access to a fair hearing. And on the other hand, the substantive, because you have the procedural and substantive. Yes, como los abogados sabemos, distinguimos la cuestión de sustancia de nuestro derecho y la cuestión de cómo procedemos ante el juez. So the substantial right and the procedural right. The procedural right to an effective access to a fair hearing. And on the other hand, the substantive right to an adequate redress. I have been talking about that. Redress means to bring things to a previous state. Volver las cosas al estado anterior. That's redress. And that means that has to do with tort law again, daños y perjuicios. Adequate redress, yes, to turn the things the way they were before the harm. That's the redress. And this text has been taken from this European Fundamental Rights and Citizenship Program Actions. There is a handbook for techniques. There's so many handbooks that the internet is full of handbooks. So an effective remedy comprises at least 6 faculties. The right to bring an action. Yes, to file, remember, file an action, file a lawsuit, bring an action, bring a lawsuit. Those are collocations too. The right to access to a tribunal. The right to be heard. The right of defense, the principle of an equality of arms, and the principle of odi alteram partem. then we are going to see these 2 last parts because they are more difficult. So the principle of audi alteram partem. You know that in English they use also Latin, but they use Latin in a different way. For instance, they say prima facie. They don't say prima facie. They say prima facie. And they say, for instance, they say per se, and they don't say per se. They say per se. So prima facie, that's another legal term, Latin, but in English. So odi alteram pardon would be the national court must also respect the requirements of an effective judicial protection of the rights of individuals. Among those requirements is the principle of odi alteram partem as part of the rights of defense. I think that it means that that the judge should hear both parties at the same level. They are equal before the judge. That's why they are alteram partem. They are at the same level. That's one of the principles that come from effective remedies. And another one is the equality of arms. That principle is, however, an integral element of the principle of effective judicial protection of the rights. So equality of arms, I think, is the same. The idea of they are the same. They are the same level before the judge. They are presenting the case at the same conditions, in conditions that do not place it in a clearly less advantageous position compared with its opponent. That's another term, you know, advantageous. And I used to say advantages, I used to say. But today I checked it and it's advantageous. Let's see, I think that I have it here. Let's see if I have it here. I don't know whether I will have it. No, lo borré. A ver, este acá. I don't know if you are saying the advantages. Are you saying it? Are you seeing it?
Yes, we are.
Okay, so pay attention.
Yes.
Pay attention. I will put it louder. Advantageous. Advantageous. So now we can check the pronunciation. Advantageous. So the advantageous, again. Ay, como ahora. Ahí está. Advantageous. In conditions in a clearly less advantageous position compared with its opponent in the EU Court of Justice. Well, this is another topic, and I will stop it now.